All right, I'm going to go to number 3 on my list. This is 18-30023-808. John Gilbert, are you in the public iPad area?
Yes.
Okay, great. And then do I have Aaron Gilbert?
Yes.
Okay. And then I have Mr. Lawrence on this case. Good morning.
Morning.
All right, let me pull up your digital file. And I did get a draft order on this. What I understand is that this was placed on today's docket by Mr. Gilbert for an adequate cause determination. Respondent let's see. Excuse me, Ms. Gilbert, you are requesting the change in the parenting plan, correct?
Well, so I guess this started, yes. I mean, this all started with a restraining order and then I guess a change in the parenting plan. So John hasn't had visitation until he completed what he has now completed.
Mm-hmm. And I'm just looking back at the prior judicial officers' orders that are in effect. So Mr. Gilbert, fill me in on why you have noted this up on today's docket. It looks like you're asking the court to deny adequate cause to change a parenting plan.
I want the parenting plan to stay exactly the same as it is. I want my visitation rights back. I did the drug evaluation. I did the hair test. I did everything came back negative. The evaluation, there's no recommendations, no nothing. I do not do drugs. I don't do any of that. I just want my visitation rights restored back exactly how they were.
So what I'm having trouble seeing, and I will acknowledge, especially given that your docket starts with the number 18, that you folks have been involved in this case for a very, very long time. You've had other judicial officers in this case. I am stepping in once many, many years have gone by. And I'll probably turn to Mr. Lawrence next. I think my concern is exactly what has been filed in front of me today appears to just be Mr. Gilbert asking me to find that there's no adequate cause to change a parenting plan, but I'm not really sure that's in my purview at the moment. So typically what would happen is the person wanting to change the parenting plan would file a motion asking for me to find adequate cause to do so, and then the opposing party would object. And it looks like we might be doing this a little bit in reverse. Mr. Lawrence, help me out here.
Yes, Your Honor. The action that we're currently in court for was the result of Ms. Winkles being supplied with, I believe, a Facebook post by Brenda Gilbert, and that is John's current wife. And she was alleging that John was using drugs, that they got involved in a domestic violence dispute. So this was supplied to Aaron, who became very concerned about what was going on when Max goes to visit. And so Aaron filed for a modification of the parenting plan. And the issue that the court was trying to deal with was to get Mr. Gilbert to undergo a substance abuse evaluation with the input of myself and Ms. Wilbanks. Mr. Gilbert contended that he had done that evaluation, but we had no proof of it. It was not filed with the court, and I had not received a copy of it, and I believe neither had Ms. Wilbanks. So we essentially put it on Mr. Gilbert's shoulders that if and when he completes the evaluation, then we would reschedule this matter and address it then. Mr. Gilbert did file that evaluation. It did indicate that they were not recommending treatment. And so that's pretty much where we're at right now. Ms. Wilbanks still has the motion to address, but it appears that the underlying fact pattern may not exist.
I see. And when, thank you for that. And when I go way, way back, I do see back in December of 2022, Ms. Gilbert had filed this adequate cause motion, and it looks like the judicial officer at that time essentially just kind of kept reserving on it pending the outcome of some of these evaluations. Does that sound correct?
Yes.
Okay. And then there was a restraining order put in place at one time. Is that also accurate? Temporary restraining order?
Yeah,
Yes.
temporary.
Yeah.
If both
And-
parties agree just to go back to the normal visitations, can we just do that? I mean, all the evaluation paperwork, the drug test, the hair test, everything's came back negative.
So I was just, served this or, got it in the mail over the weekend, so I did not have time to respond. I was considering asking for like a continuation just because all of this is done, but I have still heard that things are not going great at his house. They're still fighting. His wife just got a DUI. I mean, things are not going great over there still. So that's where I am.
Yeah.
I wanted to do a possible ask for more just so I could get maybe police records to see if any more action has been happening at their house for the last few months.
And when did you say you received this motion, ma'am?
Just in the mail over the weekend. I mean, I didn't get it until Sunday, but yeah.
Okay. Mr. Gilbert, when did you mail out this motion?
It should have been right after I got it, like on a Wednesday or so.
Okay.
Could have had it for a few days in our mailbox,
You think you mailed it this past Wednesday?
like 2 weeks ago on Wednesday.
Oh, 2 weeks ago on Wednesday. Okay, well, she's telling me she got it this weekend. What I would like to do, I better understand the posture of this lengthy case. I think that we should actually set this for the show cause hearing. This will be both based on Ms. Gilbert's original December 2022 motion, where the judicial officer simply reserved ruling on many months. This will also include, sir, your motion to ask this court not to find adequate cause. I take at face value that Ms. Gilbert says she was just served this weekend. That wouldn't be adequate time to proceed today. What I'd like to present to the two of you is either 1 or 2 week, very short, set over. And at that time, we will do a show cause hearing where the two of you will testify. I'll take into account any written documents that you've submitted, and we will make the final ruling on whether there's adequate cause to move forward with changing the parenting plan or not.
So if we both agree, can we go back to the same old parenting plan?
If you both were in agreement just to strike the adequate cause motion, yes.
Okay.
So what we have outstanding is an adequate cause motion and an adequate cause motion objection. If the two of you were striking that, then yes, we would not be making changes to the parenting plan.
All right.
Okay.
I strike it, but I
How,
would like it too.
say that again?
I would like to strike it down or whatever, but I also want to spend time with my kid this summer too.
Yeah. Would, ma'am, would 1 week be enough time to next Wednesday? Would that be enough time for you?
Yeah, I think so. I mean, I have to request the records and I don't think you get them back right away, but a week I think should be okay.
Okay. So let's go ahead and go to the show cause on the adequate cause motion. I'm going dating that motion all the way back to December of 2022. And Mr. Lawrence, are you available on next Wednesday at 9 a.m.?
Yes, Your Honor.
Okay. All right. So I'll see you back both just in 1 week, and we will have that show cause hearing. I will make a determination about the adequate cause.
Perfect.
Okay.
Thanks.
Thank you. I have number 3 on the docket, John Gilbert. I believe you're in the iPad booth if you want to unmute.
Yes.
This is 18-0023808. And then Aaron Gilbert, I see you there online.
Yes.
Okay, let me just get into your digital file here. Okay. So what we did at our last hearing was set over the show cause hearing because it sounded like to me that Ms. Gilbert wanted some additional time to respond. And I have received on August 7th some additional filing from you, Ms. Gilbert.
Yes. Which I just realized I didn't give to Keith, but yes.
That you didn't, give that information to the guardian ad litem?
Yeah.
Okay. So hold on, I'm just working with okay. So let me just start with Mr. Lawrence. It sounds like there was additional filing from Ms. Gilbert that you may not have in support of the motion to change a parenting plan.
I have not seen those, Your Honor.
Okay.
Sorry.
And it looks like it's, probably relevant information for the guardian ad litem by way of police reports, which my gut instinct tells me are probably a big basis for you bringing this motion. Is that correct to say?
Correct.
Okay. So what I'd like to do, unless Mr. Lawrence wants to move forward anyway, but my preference would be for just to set this out 1 week and have you get that information to Mr. Lawrence so that the court is able to have his input before making a decision on this.
Can I object to that, Your Honor? I can't miss work every week to continue on. I'm going to lose my job. I'm currently paid up on all my child support, everything else. I did everything the court's asked. The drug test, all the samples, everything's came back negative.
Go ahead, ma'am.
I mean,
I
sorry.
heard you, Mr. Gilbert. I heard you, Mr. Gilbert. I'll hear from the other parties and then I'll make a decision.
I mean, I did let Keith know that I had found out that that Brenda was arrested and had her daughter, kind of taken out of the home. She just has supervised visitation too. So, and then I guess, so my next step is, wanting to get the information from Lewis County, so I can see what's going on with her case. So yeah, I don't know if you want to just do another week or if we want to wait until I actually have that information, from from Lewis County.
So here's what I would say, ma'am, if this is your motion for adequate cause to change a parenting plan, but you have additional information that you plan to file in support of it, the court's inclination would be simply that we would strike today's hearing. You renote this when you're ready for the court to decide a motion on adequate cause.
Oh, okay. So after I have the information, then I would just file it and set a new court
Right.
date.
I would say bring this motion back before the court once you believe the filing is complete and you're ready to go to hearing. It sounds like the last time we met and then today there's additional information you want the court to consider.
Right. Unfortunately, yeah. Last time I didn't realize it was going to open a can of worms. So
Yeah, right. I get it. Mr. Lawrence, I guess I'll turn to you. It sounds to me like that Ms. Gilbert, the moving party, isn't necessarily prepared to move forward on her adequate cause motion today.
That's fine, Your Honor. I did review the records in Odyssey to see what I could find on Brenda Gilbert. I didn't find anything that I thought may have been an issue. And so whatever arrest she may have had isn't resolved yet. And so I think that having Ms. Wilbanks renote it once she has the information she wants us to look at would be the best course of action.
in the meantime, I did want to say, John does supervised visitation and Max, our son, is in sports and has asked if his dad can come to his games. So I don't know if that's a possibility in the meantime, if it's, obviously I'm going to be there. So is it okay that John comes to his stuff down here? Or?
If you, ma'am, as the moving party and the one with the concerns in this case, are open to allowing him to be in person at the games, the court has no issue with that whatsoever.
Okay, thank you.
Mr. Gilbert, what I think that we'll do then is, I'm not setting a new date. Ms. Do you still go by Gilbert, ma'am?
Yeah.
Okay. I just want to make sure I was using the right name. I know sometimes these cases start with the married name and then change. So Ms. Gilbert, what I would ask, because there is a bench order in place that does put some restrictions on visitation, I would ask, I'm not going to set a date, but please get this back in front of the court in a timely manner so that we can fully address for Mr. Gilbert what that looks like going forward. Okay.
Yes, definitely. Thank you.
But Mr. Gilbert, the court has no issue with you attending sporting events per Ms. Gilbert's request.
Okay, I'm asking the court. I was ordered to do the hair follicle test, this, that, everything else and stuff. It all comes back. I said I don't do drugs. Everything's came back negative. I got no evaluations. What does the court want me to do so I get my week on, week off before summer's over? She will never be happy. She's not going to let me give visitations. I need to address the court. What am I failing at?
Mm-hmm.
I paid all my child support. Every drug test came back.
So Ms. Gilbert, let me ask you this. The reason the court puts changed visitation was because you filed a motion for adequate cause wanting to change the parenting plan. Are you still asking for supervised visitation versus going back to the original parenting plan?
Yes.
This
whole thing.
Hold on, Mr. Gilbert.
Sorry. This whole thing was not just about drugs. It was the complete chaos that is happening at their house, and it has seemed to continue. And so that's my concern. And just this morning, Mr. Gilbert texted me and said, I'm probably right that Max probably shouldn't be there right now while he's going through this. So yeah, I just, until I know that him and Brenda are done officially, I just feel like it's not a good environment for Max.
Okay, well then, ma'am, I am going to change my ruling somewhat, because here's what's happening. You have filed a motion to change a parenting plan. The court has put some additional restrictions in place without actually making a determination on that. But you're now saying you want to present more information. and you're not ready to move forward on it. But I think Mr. Gilbert has an excellent point, which is in the meantime, while you're wanting to document the file with more information that we don't have, he's losing out on time with his child.
I mean, I do have the information that, you know, his wife was just recently arrested because they got in a huge fight and he called the cops on her. That was just a month ago. So
Right.
nothing has calmed down.
Okay, then what I want you to do, here's going to be my ruling. Mr. Gilbert, it is going to require you all to come back to court next Wednesday. I'm going to, rather than keeping this out, I think you make an excellent point, sir, that the court has put additional restrictions on you for a lengthy amount of time without this matter moving forward. I do think we need to have resolution to that issue. So I think that I know, I understand what you're saying about missing work, but I do think you all should come back next Wednesday at 9 a.m. Ma'am, please get that information that you filed with the court to Mr. Lawrence. And I do want to make a ruling on your request to formally change the parenting plan, okay?
Okay.
So we'll be able to make a ruling next week and find out something.
So what it'll initially be is a ruling on whether there's adequate cause to change the parenting plan. If I find adequate cause, I can put a temporary plan into place and then set you all for trial on the permanent parenting plan. Or the court can find there isn't adequate cause to change the parenting plan.
Okay, I guess summer's gonna be over. All right, thanks.
Yeah.
He
Okay.
is the one that took 6 months to get a clean drug test.
And there's no question in front of you. Please
Yes.
get that information to Mr. Lawrence. Mr. Lawrence, are you available next Wednesday on the 16th?
Yes, Your Honor.
Okay, I appreciate it. We'll see all the parties back on that date.
Thank you.
Let's see, and then I have Gilbert and Aaron Gilbert. Do I have both of you present?
Yes.
Yes.
Okay, great. That's you and iPad 1. Thank you. And I do have Mr. Lawrence on here. Give me a second just to pull up your digital file. Okay. So when we were together last on August 9th, I think one of the concerns the court raised was we have this adequate cause motion that's been hanging out there. There's been ruling reserved on it, but in the meantime, a judicial officer had changed, at least temporarily, visitation pending some additional information coming in. I've reviewed the evaluations or not evaluations, but the UA reports that have come in. I think that was one of the things the prior commissioner was wanting. I've looked at the documents from the original show cause motion. I haven't, Ms. Gilbert, received any additional information. I think when we were together last, you were maybe going to supply some additional information to support your request for adequate cause finding.
Yes.
I haven't seen that. So first, I'm going to turn it over to you, then Mr. Gilbert, and then I'm going to get input from Mr. Lawrence. So
Okay.
go ahead, ma'am. Where are you at with evidence and your request to change the parenting plan?
I did file paperwork on Friday. So I received, you know, a notification that John's wife had her daughter, you know, taken away or lost custody. And so I got that information and filed it with a declaration on Friday, just with some other stuff, a text from John saying that he agreed that his house is not a good place for Max. And a declaration from his stepson about John's behavior.
Okay, so I'll tell you, unless you provided a bench copy, which is a second copy for the clerk to give to me, there's absolutely no way I would receive your documents if you dropped them off Friday. So they're not in our digital system either. We have nothing scanned in since
I
August.
don't know what that means. I have to request specially for it to go to you?
No, it just means you can't drop things off 3 days before a hearing. It's not going to get scanned in administratively, and it's not going to make its way to me unless you deliver a second paper copy that's called a bench copy. So I have nothing that you're discussing in front of me. Okay.
I thought that it just had to be filed by Friday. I must have misunderstood. I mean, last time I filed it on Monday before court and you had it then, so I just must have misunderstood, but I did file something, so I'm not sure.
Okay. Let me chat with Mr. Gilbert. Mr. Gilbert, have you received the documents that she's referring to?
I got an email from her. Yeah.
Okay. What's your position on this? She's seeming to allude that you are in agreement that your house is not a suitable place for the child right now.
It is now. I'm the only one staying at the house.
Say that again. I didn't catch it.
I'm the only one staying in the house, so it's a safe spot for the kid.
Okay. You're talking about, so Brenda is out of the house?
He's not staying in the house right now. No.
Okay. Well, I don't have anything in front of me.
I did give it to Keith, the guardian.
Okay, I'm gonna talk to Mr. Lawrence shortly. Anything else, Mr. Gilbert, you want me to know? Are you objecting to a change in the parenting plan at this point?
Yes, I object to it. I want it to stay exactly the same.
And as I see, you haven't had visitation now for quite some time because of these temporary orders. Is that right?
A very long time.
Okay. And I did receive your negative and review your negative UA results. So let me turn it over to Mr. Lawrence and get some input. It sounds like, Mr. Lawrence, you may be privy to documents I haven't seen, so I'll ask for a little input from you.
Yes, Your Honor, I did receive an email from Erin last week. And as she indicated, there was several documents in there. There was a statement by Brenda's current husband, or past husband, rather. There was a statement from Aaron and John's older son. And from what I gleaned out of the number of documents that she sent, is that there's complete chaos going on between Brenda and John in their home. And I would not recommend that the court allow visitation if the two of them are residing in the same home. John has undergone his drug and alcohol evaluation, but if the two were together, I would recommend that the court consider John undergoing a psychological evaluation with a parental risk component. If those two can't separate somehow, this is no environment for Max.
Mr. Gilbert, do you want to respond to that?
Yes, like I said, we're not living together. I was a father before I was a husband. I'm a dad. And I lost my parenting rights over a bunch of stuff that I proved. I don't do drugs. I don't do any of that stuff. So yes, we are not living together.
Looking to see, and I don't have confirmation of that, sir. I can certainly take your word here right now, but I don't have a declaration to that effect from any individual. I'm looking to see if we have an order on the adequate cause. Ms. Gilbert, have you filed a proposed order on the adequate cause decision?
The proposed parenting plan?
No, it's called an order on adequate cause.
Oh, I do not believe so.
Okay.
I do have something to say about him and Brenda being together if I have the opportunity sometime.
Go ahead.
Oh, just that he has, I mean, this has happened multiple times where he says that him and Brenda are no longer together. And then they are together, unfortunately. And I do believe that this is just a lie, unfortunately, to get Max back. Anyways, yeah, I just do not believe that even if Brenda is not living there, which I do not believe that she's not, but if she isn't, I believe that would just be temporary. They very much have a history of breaking up and getting back together, so. Until things are final, I would not like Max to go there.
So here's what I'm going to do. I think this motion for adequate cause has been hanging out there way too long, and the court needs to make a ruling. Based on all of the evidence in the file, including input from Mr. Lawrence, I do believe the first ruling I'm making today is that there is adequate cause to change a parenting plan. This doesn't mean that I'm adopting any specific parenting plan right now. What it means is I believe there's enough evidence to move this forward to a trial, but maybe mediation first on what the new parenting plan should look like. So after today's docket, I'm going to fill out what's called an order on adequate cause to change a parenting plan. I will find that Ms. Gilbert, who was initially the respondent in the underlying action, did make a motion for adequate cause decision, that today we did hold the adequate cause hearing, that I have jurisdiction over this case, and that I am finding that there is adequate cause to hold a full hearing or trial on the petition. The trial date will be set at a later date when we have further, when we're ready to get to that point. The other findings I'm going to put in this order are that for now, the prior judicial officer's temporary orders suspending visitation remain. Mr. Lawrence, what were the evaluations you were recommending? I wrote down parental risk assessment or component.
Right, yeah, a psychological evaluation with the parental risk component.
Okay, I am going to add that, Mr. Gilbert, to the order as an affirmative obligation that you will need to do. What I'm going to do after that is, and Mr. Lawrence, do you still have time with us on this case to remain as GAL?
I'm available to remain, however, my funds have run out.
I would like to keep you appointed to this now that I am finding adequate cause and moving this on to a hearing, trial, or mediation on changing the parenting plan. I will approve a request for additional time and money on this.
Okay.
Do you have a template order you could send over to me ex parte on that, or do you need the court to do it?
I don't have a template, Your Honor. I'm sorry.
Okay, let me just make a note for myself. And I'll get that done after docket as well when I do the adequate cause motion.
Your Honor, can I please at least just get the weekends with my kid?
Not right now, sir. I do want, what I'm going to do is set a review date. And we're going to set it 30 days out. And I would like you in that time, as best you can, certainly understanding it is difficult to get into medical providers. I would like you to get the psychological assessment with the parental risk assessment. I am also hopeful that by me approving some additional time and hours from the GAL, that we can kind of get to the bottom of what your living arrangement with Brenda is. I'm not convinced standing here right now that more likely than not, the two of you are permanently not residing together. So I am going to need some further input on that. So my hope is when we come back in 30 days, it'll be both a review hearing on kind of the immediate visitation issue and your compliance with the psychological evaluation. But then I would also like to address at that hearing whether you're ready to go on to the full hearing or trial on permanently changing the parent plan or not. Okay.
Okay,
So that's going to be, I'm looking at September 13 or 20. Mr. Lawrence, do you have a preference?
Your Honor, the parental risk assessment can take several months. So,
Oh, okay.
so the 20th would be preferable. I can address the living situation, and I can address whether or not Mr. Gilbert is attempting to set up an appointment, or he may even have an appointment, but it may be down the road.
Let's do that. I think that's a great idea. And thank you for that additional clarification. So let's set this to September 20th at 9 a.m. back on this docket for a review, for essentially a status review on those two issues. And then we will also talk about, I know Mr. Gilbert, you want to move this forward. We can talk about whether we're ready to get you guys sent on to, mediation or a trial. Okay.
okay.
Any questions for me on this matter? Otherwise, I will get the adequate cause findings signed and filed. I'll get the additional time and money approved for the GAL, and then we'll see you back on September 20th.
Yeah, since Keith brought it up or what, so where's the best spot to get these evaluations?
Your Honor, the only person that I know of locally that does that is Dr. Stephen Maharg at Northwest Psychological in Longview.
Do you have any idea what that costs?
It runs around $1,500. The last I heard, I don't know what his current rates are, but I can provide John with Dr. Maharg's contact information and so he can get started.
Okay. Thank you. I appreciate that. All right, Ms. Gilbert, Mr. Gilbert, you are free to log off.
Thank you.
And
Thank
then
you.
Mr. Lawrence,